but it does take.
You're going to jail. You're going to jail, friend.
It says felony theft by deception warrant for you.
On February 21st, 2025, officers in Athens, Georgia, arrested 2 women for coordinated retail theft at a Target location. This analysis examines the legal framework governing the arrest, the use of force applied, and a felony interstate warrant that surfaced during booking and what the law says about each. Under Georgia Code Section 16814, shoplifting merchandise below $500 in a single transaction is a misdemeanor. The merchandise recovered, valued at approximately $260, places both subjects firmly within misdemeanor territory under that statute. The threshold question is whether a full custodial arrest for a misdemeanor is constitutionally permissible. The Supreme Court resolved that question in Atwater versus City of Lago Vista in 2001. The court held that a warrantless custodial arrest for a minor criminal offense does not violate the Fourth Amendment, provided the officer has probable cause. Probable cause here was independently established through direct loss prevention observation, not a tip, not a hunch. Direct surveillance of the Concealment Act satisfies that standard without ambiguity.
The register and then like buying something super cheap and then all the other stuff's in the purse.
It's cool.
It's very cold.
Mine takes time. Crime doesn't pay. But it does take.
You just remind me of those old commercials that were on VHS tapes. Piracy is theft. Theft is a crime.
You wouldn't pirate a car, would you?
You wouldn't steal your neighbor's car, would you? Then why Paramount Pictures Shrek 2?
Like kicks through the screen. Yeah, we saw you take that VHS tape. So the Simpsons, you're going to jail.
You're going to jail, friend.
Walk that way.
Alright, both of y'all are detained right now. You're not free to leave. Go right over there.
Because you're under being stopped for shoplifting. Tell me your name. Alright, let me see that first.
You don't know what's all in my damn purse.
Well, we're taking it. Alright.
I can tell. Hey, you don't. You take it.
Grab
Don't
your
put your hands.
Don't put your hands.
Don't put your hands.
Put your hands.
Don't put your hands. Don't put your fucking hands.
Put your hands
Get
behind
your
your back.
hands off of me. I'm
You're
not
under
even.
arrest. Put your
I'm
hands
under
behind
arrest
your
for
back.
what?
Shoplifting. Shoplifting.
Child is right here.
On
My child is right
Put your
here.
hands behind your
I'm
back.
not doing nothing. Could you
Put your
stop?
hands behind your back.
Could you stop? My
Put your
child is
hands-
right here. Stop. Oh, my arm. Stop. Jesus Christ. T.
That's from today? No, that's from. That's oh look, it looks like they went to another Target earlier.
Yeah, I bought that this morning.
But that's 9:32 this morning.
Yes, I bought me a sample of a Billie Eilish perfume.
That's what I'm saying.
Let's see if she put it right here. Oh, you can't because
Sit down!
it says it. Can you stop putting your hands on me?
No, you're going to sit down.
You are under arrest. You cannot keep getting up.
Call my mama. See, call my mama.
Yeah, you need to call somebody to come get the baby. Did she participate too? Did they both participate? Alright, somebody needs to come.
To her and she put
Somebody needs to come get the baby because you were both.
Are you gonna sit
together.
seated?
I need you to come get. They're trying to arrest me.
No, we are arresting you.
And they just threw me to the
Are
ground.
you anywhere?
And we were in Target.
I will be in just a couple of minutes.
Yes, in Athens.
We had a use of force and I was involved.
They just threw me to the ground. Everything right here. I'm so serious. Just come. I need you to come get. They're trying to. They arrested me and T.
I know. I just found.
They said I was obstruction of Leo. Okay.
9:32 and she bought some her. So what I'm saying is she might do the same thing.
Give me a second. Give me a second.
You don't control the
Let
situation.
me tell you something.
No,
That's
no,
my
you
fault.
shut your mouth.
You get your finger out my face.
You're putting your finger in my face. Look at you upsetting your kid again.
Because I asked for my phone.
You are under
I
arrest.
can call my grandmother too. What is wrong with you?
You're not calling shit now.
Give you both of these females' names.
You read both 27.
Yeah, I ran both. Have y'all ever been arrested for shoplifting?
No.
Make sure you run a criminal history on both of those subjects.
Listen, you gonna chill out?
This is my child.
I mean,
I know.
she certainly got obstruction.
Well, yeah.
That's not what we asked.
But hang on.
I can't. Look, I'm sorry.
Hang on, let me talk for a second. Okay?
Calm down, miss,
I'm trying to give you the option here between a year in prison or not a year in prison. All right? So if you chill out and you stay calm with this, then I'll just call it misdemeanor since you're so small. It's not like you're really going to hurt me.
I think misdemeanor's probably a little better.
Yeah.
So you'll be charged with misdemeanor obstruction and shoplifting. You'll just be charged with
As
shoplifting.
long as you stay chill, we'll keep it a misdemeanor,
I'm
okay?
trying to stay chill. What I was trying to explain to you, what a trigger is when someone putting their finger in my face. I don't.
No,
Okay,
you
but
put your finger in my
that's
face
not-
first.
But I wasn't trying to.
And you were trying to grab your purse from me. And
Yes,
you can't
but
do that.
All right, argue it one more time, and it's felony. That's all I'm going to say.
When Subject 1 attempted to retrieve her purse from officer custody, she crossed a legal threshold that transformed the encounter. Under Georgia Code Section 161024, obstruction of a law enforcement officer is a misdemeanor when no force is involved. It becomes a felony carrying 1 to 5 years imprisonment when physical force is used against the officer. The officer warned Subject 1 of this distinction directly before applying any physical control. Verbal warning before physical intervention is required by use of force continuum doctrine, and the officer followed that sequence correctly. The physical takedown is evaluated under Graham versus Connor, decided by the Supreme Court in 1989. Graham establishes that the reasonableness of force is judged from the perspective of a reasonable officer on scene at the moment of the decision without the benefit of hindsight. The relevant factors at the moment force was applied. Subject 1 was actively resisting handcuffing. She had already attempted to retrieve evidence from an officer, and her continued resistance showed no signs of de-escalation. A controlled takedown without weapons falls within established parameters for the resistance level displayed. Under Graham, the force applied was objectively reasonable. However, an infant was present in immediate proximity throughout the physical struggle. Industry best practice and the tactical standard taught in law enforcement training requires a secondary officer to take physical custody of any dependent child before force is applied to a primary caregiver. There is no indication on this footage that this protocol was executed proactively. That is a procedural failure, regardless of the force outcome. The most legally significant moment in this footage is not the physical struggle, it is what the officer said immediately after. The lead officer offered Subject 1 a conditional arrangement, comply and remain calm, and the obstruction charge stays a misdemeanor. Continue resisting and it becomes a felony. He then added, quote, "Since you're so small, it's not like you're really going to hurt me," as his stated justification for keeping the charge at the misdemeanor level. This is where the analysis becomes critical. Charging decisions in the American criminal justice system are formally vested in prosecutors, not patrol officers. A patrol officer does not have authority to determine whether a charge rises to the felony level based on his personal assessment of how physically threatening a subject appears. The legal threshold for felony obstruction under Georgia Code Section 161024 is whether physical force was used against the officer, not the officer's subjective evaluation of the subject's size. Conditioning charge severity on continued compliance creates a coercive dynamic courts have examined critically. While this incident may not rise to the level of a constitutional violation, it exposes the department to civil liability risk. An officer who ties charge elevation to a subject's demeanor, rather than to the legal elements of the statute, is operating outside the proper boundaries of patrol authority.
Listen. When the police are here and you're stopped, we can take your purse and you can't grab it from
I
us.
understand, but I don't like when y'all are trying to talk.
I'm sure you don't. I don't like when you steal.
Which one is Miss? You?
What are you talking about?
They're saying you got a warrant.
I don't have no record. You've been arrested.
All right, you got a warrant for shoplifting.
Have you ever shoplifted somewhere else, like Darien County?
No, I don't even know what that is.
We'll look and make sure it's the right person. But you gave them the information.
Varsity?
I'll look.
No.
So what do you guys do with the merchandise now? Like sell it?
What am I gonna do?
Oh, don't even do that. Don't even play a race card when you're literally stealing out of Target.
What am I gonna sell it for?
Unreal.
What was I
No responsibility whatsoever. None.
I'm not talking to you.
Okay, it's felony, I guess.
I really
Then.
don't. I'm not
Crazy.
even saying anything to you, and you just keep
That's just what we
starting.
asked.
Because you're playing a race card. You're
It's not even
shoplifting.
about. Please stop talking. You're aggravating.
So what do y'all do?
Okay, so no one was gonna sell it for anything. It's at all. Just yeah, that's like
We were at
I wasn't gonna sell
No.
it. It was just the way he
Yeah.
said it. Like I
What's your date of birth?
yes.
Have you ever been to Tennessee?
No.
It's a theft by deception charge from Berrien County in Tennessee.
What did I steal from Tennessee?
I don't know. It's theft by deception, and what that means is like you stole by trickeration. I don't know. Have you been to Berrien County, Tennessee, outside of Nashville?
No.
Well, it's your date, your name, and your date of birth. We'll get to the bottom of that. But it's a. How old are you?
I'm 19.
Yeah, it says felony theft by deception warrant for you.
I'm so confused right now. I'm not even playing.
Well, look, I'm not going to say it's never happened. Somebody could have gave your name. Have you ever even been to Tennessee?
One time for a trip.
While you were up there, did you do something like stay at a hotel and didn't pay or something weird like that?
I stayed at a hotel, but I didn't pay for the hotel. Did like my
Was it in your name or something?
No, it wasn't. Nothing was in my name.
I don't know what happened because it's up there. They took a warrant on you. You're going to have to get to the bottom of it.
Literally nothing was in my name.
Somebody took a theft by deception warrant against you. So listen, you'll have your chance to take care of that, but we had nothing to do with that. When we just checked your name, it came up.
How many charges is there?
It just said one now it sounds like they want you, so it looks like you'll go to our jail and they'll come get you. Well, unless
Don't sweat it for right
unless somebody may be able to call up there and figure it out.
Calm down, sis, calm down.
This may be a small thing and nothing big to worry about. We're working about it right now. Don't drop the baby while we're having the panic.
Everything went. Where were y'all at?
You have the video
Oh, I'm trying to figure it out.
It was a hotel. It was.
So y'all did go stay at a hotel.
Stayed at a hotel, but it wasn't in my name.
But did anything happen while you were there that they could have?
No,
Did something happen maybe with the payment for the hotel?
I didn't pay the hotel. I
So
didn't
what
have
in your
nothing to do with
name?
the
Well, I'm
hotel.
trying to say, was there anything else y'all went where they could have said y'all took something?
I didn't go to no stores. When I eat, I paid for my food there. I went to a gas station. I paid for my snacks there. I can't call who I was at the hotel with.
Well, no, well, but listen, the thing is, the warrant, if a warrant's already been issued, you're gonna have to take care of that with the people up there. Let me go see what the extradition and stuff says. Let me help you out.
So basically, we're gonna have you guys barred from this location. Both target locations in Athens County. So that includes the one downtown as well for 2 years. If you guys are seen anywhere on target property, you guys will be arrested for trespassing, and that includes this entire parking complex, this entire shopping center.
Okay.
So next thing I'm gonna do is I'm gonna hand y'all these. One's for our record, one's for y'all, and then I'm gonna have y'all's picture taken just for Target's database.
And put it where?
It's just gonna be like on Target.
It's not like they're gonna hang it on the damn.
Yeah, it's not gonna be like on
Nah,
Facebook.
they keep it themselves.
So they're supposed to call me back, but it looks like the incident was from 2024. But
She said last year.
The incident was from last year, like, I don't know, November 2024 or something
I've
like
been
that.
in Tennessee since some of those last time I was in Tennessee.
Well, I don't know the whole details, but they're supposed to call me back and tell me what the warrant is actually. It does say full extradition. And your middle name's like Janaya, right?
Janaya, yeah, but
So
I
that- so what-
I was
well,
down here in Athens.
Well, I don't know.
Well, things take time.
So just to prepare yourself, what's gonna happen is you're gonna go for our shoplifting. Once you're clear on that charge, you're gonna be held for Nashville, and they'll send somebody down to get you. I mean, I'm not gonna hide anything from you, but to help you out. I'm calling them so you can know exactly what they said you did. Okay?
Friends, you know.
Yeah, that's why I was saying, like, you want
Yeah, but
to
calling your friend is not going to do anything.
That's a different state. They ain't gonna be able to do nothing.
During the name verification process, a felony warrant surfaced from Bryan County, Tennessee, charging Subject 1 with theft by deception. The warrant carried a full extradition designation. Tennessee Code Section 39-14-116 defines theft by deception as obtaining the property of another by creating a false impression through words, actions, or the deliberate concealment of material facts. This is a distinct offense from retail shoplifting. Theft by deception commonly involves schemes such as using a fraudulent or stolen payment method, providing false identification, or misrepresenting one's identity to obtain services. The felony designation on the Tennessee warrant indicates the value threshold exceeds what would qualify as a misdemeanor under Tennessee law, or that the specific conduct involved aggravating elements. Full extradition means Tennessee has elected to pursue the subject regardless of where she is arrested in the United States. Under Georgia Code Section 171330, Georgia is a signatory to the Uniform Criminal Extradition Act and is legally obligated to honor that hold. Subject 1 was not aware or claimed not to be aware of the warrant's existence. That is legally irrelevant. A warrant does not require the subject's knowledge to be valid and enforceable. Neither subject invoked the Fifth Amendment right to remain silent at any point during this encounter. Both made extensive statements to officers voluntarily and without prompting. The Fifth Amendment protects against compelled self-incrimination. Miranda warnings are required only when a subject is in custody and subject to interrogation. The officers here were engaged in general conversation and explanation rather than formal custodial interrogation, a distinction courts have consistently recognized. However, the practical consequence is the same. Subject 1's statements about the Tennessee trip, the hotel, the travel companion, and the payment arrangement are potentially admissible and may assist the Tennessee prosecution. Subject 1 also attempted to access her phone during the arrest. The officer denied this access. That denial is legally defensible. The right to a phone call is a statutory right that attaches post-booking, not at the moment of arrest. The Sixth Amendment right to counsel attaches at the initiation of formal proceedings, not during a field arrest.
Akiri, this is your mom, right?
Yeah.
You want her to take the child, and what else do you want her to take?
I need your keys.
You want to release everything?
Yeah, I want to release everything. So I don't know your number by heart.
They'll let you write it down. Just make sure she keeps it.
Hi.
And she poops.
Now she'll be able to she'll have a bond. You can get her out, but she won't because hey, they wouldn't tell me what it was for. But like I said, it's felony
You
theft
want me
by
to call your
deception.
mom? I'm coming.
Hey, you got to get taken care of one way or the other. I know it sucks, but nothing we can do about that warrant. If somebody pays her bond.
I mean, I got
Hey,
my
you her
card.
mom?
Yes.
So let me tell you what's going on.
I'll kind of read.
Okay.
You can read.
So they were
this one, sorry.
shoplifting, they were putting makeup in a purse, so she's going to jail here for misdemeanor shoplifting. When we ran her name, she has a warrant out of Berrien County, Tennessee, which is Nashville. It's
Just like you.
it's for felony theft by deception, and they're saying it's full extradition. So what that means is they'll extradite from anywhere. So theft by deception generally means you steal by committing like trickery. So they're saying she committed some kind of trick to steal. We don't have any other details about it. She went on a trip there apparently with her cousin.
Yeah, did they say when it's to like the date?
It was like a year ago. But the warrant is recent, so I don't know if it's
Recent as in like I'm saying.
The warrant I saw, it said it was February 2025. So they just took the warrant, but it may have been they alleged they did something last year when they were there, and they just now got the warrant.
Because we
That-
went to the season in September with Maya, right?
So while y'all were there, they're saying she committed some kind of theft. Now you can call up there. I tried to call and see if they would tell me what the warrant said. They wouldn't do that because what happens? She's got to go to jail here for shoplifting, and when she gets there, that Tennessee County will place a hold on her if they want her. It says to us it's full extradition, so 99% chance they will. If it says full extradition, they're going to extradite. We have nothing to do with their warrant, but it's Berrien County, Tennessee. I guess Nashville probably goes in like several counties. So if you want to look up Berrien County, Tennessee, and try to call up, figure out what we can do. But it says full extradition, so what that means is probably they're going to send somebody down to get her. And I'll just be honest with you, it probably won't be till Monday. Because usually
Makeup. Do you get paid today? Do you get what? Are you still? What are you doing at Target? We supposed to be boycotting Target. Why are you here?
same thing for you.
Why are you here?
You just called him.
Hey, don't look.
There ain't nothing.
I'm talking about today. Damn that today. Why are you in here stealing? Hello? Makeup?
Socks and razors.
You don't have. You can't afford that.
I can't.
So what?
I don't know.
What did they have, sir? Just these makeup, socks, and razors. And I think this little protein stuff.
So it's like maybe $260 worth of stuff. They were like working together, handing it to each other. So they both go for shoplifting, but
You thought you were gonna get away with this in Target?
it's a misdemeanor shoplifting here. But like I said, it sounds like the stuff she's got up there is a little more serious because it's a felony, and it does say full extradition. So that means if it says full extradition, usually that means if you get arrested in California, they'll come get you. A lot of places it ain't like that. So
I'm gonna need you to be honest about this Tennessee thing.
She's been acting like she has no clue. She
I
really
don't have a clue. I didn't know I
may
had
have
to do
been
my
something.
record.
It could have been something. The person she was with did it, and they charged them both. I was asking if she stayed at a hotel, and maybe like they stayed in the hotel under a false name.
I forgot what hotel.
Did y'all
You said it was under your name.
No, it wasn't under
Well,
my
she's
name.
saying it wasn't under her name.
I
Maybe
didn't even have to put my ID out.
it could have been something as stupid as the girl who you were with. Maybe she gave a fake name and paid with a stolen credit card. I don't know. It could be something like that.
You don't know why she would do that.
No.
How long did y'all stay there?
For like 2 or 3 days.
That wouldn't be a
Back in
felony now.
September.
I tried to call and just see what the warrant said because she's been acting the whole time. She really has been acting like she doesn't know what it's about. So, but like I said, I would just Google Berrien County, Tennessee, maybe call them, and once they confirm the hold, maybe they'll tell you a little more. But yeah, they're not going to come pick her up. They could come this weekend, but I doubt it.
And you. So you probably could lose your job, and now you supposed to be going to the Air Force. Now you got this shit on your damn background. What y'all was thinking? So you know you're gonna be in jail the weekend. You know that, right? Finna figure out how uncomfortable that is.
Alright. Let's go. You grab her, I'll grab her. Stand up. Take the C4. We're not gonna be able to transport both. We still got the stuff from the last case.
Yeah.
Did you already search her?
Huh?
You already searched her?
Yeah, her, yeah.
Okay.
Did you already get her?
No, I was waiting for you to clear this up.
Other side.
Face that way for me again. I'm gonna have to search you real quick. When I get to any sensitive areas, I'm gonna use the back of my hand, so I'm not gonna grab you or anything like that, okay? You have anything on you other than your phone? Which I'll put.
The lead officer receives a B-. The arrest was legally grounded. Probable cause was established. Verbal warnings preceded physical force. Force was proportionate and within gram parameters. No weapons were deployed against an actively resistant subject. However, the conditional charge level negotiation was improper. It conflated patrol authority with prosecutorial discretion and introduced a coercive element into a custody situation. The failure to proactively secure the infant before applying force represents a procedural gap with real safety consequences. These two failures prevent a higher grade. The secondary officer receives a B+. His management of the family communication was exemplary. He explained the extradition process accurately, acknowledged the limits of his own knowledge, and delivered difficult information without deflection or minimization. The only deduction is shared with the lead officer. No proactive intervention to secure the infant before force was applied to the primary caregiver. Subject 1 receives a D. The legal predicate for her arrest was established by loss prevention, not by anything she said. Every decision she made after that predicate was established increased her legal exposure. Resisting handcuffing created felony obstruction exposure. Attempting to retrieve evidence from officer custody was an independent criminal act. Declining to invoke her Fifth Amendment right provided the Tennessee investigation with potentially useful statements. The consequences: Subject 1 now faces a misdemeanor conviction, a felony obstruction charge, and interstate extradition on a separate felony warrant, are a direct product of her in-field decisions, not officer misconduct. Subject 2 receives a C+. She participated in the coordinated shoplifting scheme and bears equal criminal liability for the underlying offense. That is not mitigated by her subsequent conduct. However, she did not physically resist, did not escalate tensions, and did not compound her legal exposure during the arrest itself. That behavioral distinction is legally relevant at sentencing, though not to the charge itself. 3 legal lessons emerge from this encounter. First, in any custodial encounter, silence is the legally correct default. Neither subject was compelled to discuss the Tennessee trip, the hotel stay, or the payment arrangements. Every voluntary statement is a potential exhibit. Second, physical resistance during a lawful arrest does not challenge the legality of the arrest, it creates a separate criminal offense. The remedy for an unlawful arrest is the courthouse, not the street. Third, officers retain broad discretion in how an encounter unfolds, but charging decisions are not within their formal authority. A subject should never accept or rely on a patrol officer's verbal offer regarding charge level as a binding legal commitment. Only a prosecutor can make that commitment. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.